can just tell you that we watched all the parties involved go into the courthouse today, and none of them were prepared for anything. I mean, prepared, I say. They didn't have boxes and volumes of material to present. They walked in with legal pads and that was it. So that was a first clue that something unusual is about to happen.
Sure, and Dave, I think right now there's an interview going on near you with Warren Brown. I'm not sure if we're able to hop over to that signal as well. Warren Brown speaking to another one of our reporters.
Actually, he is, and I'm with David Jaros. He is a University of Baltimore professor, and
sure, hold tight. Hey, Dave, hold tight 1 second. We'll come right back to you.
And so
Thank you,
when
okay.
You got that already made up in your mind. When you rush into your investigation, when you don't use the police department's investigation or the sheriffs that you say you pulled in, then you get this type of result. And it's unfortunate because you raise the expectations of the community that justice is going to be done. You put the officers and their families through all of this. You drive a further wedge between the state attorney's office and the police department. And why? I mean, just do a thorough, intellectually honest investigation and then let the pieces fall where they may. But again, I've said it all along that the state decided that they were going to charge people in this case. And the interesting thing will be also with the civil cases that remain, where we were able to pull back the curtain on the thinking, the work, and that type of thing of the state's attorney's office to find out, well, what gave rise? How did you get to the decision to charge so quickly? And I think that those revelations will be quite damning.
Where does this leave the civil cases? I mean, they have a strong civil case now.
Yeah, well, I think the civil cases, they have the ability to go through a discovery process that includes interrogatories, depositions, that includes people, not only the named defendants in the civil case, i.e. Marilyn Mosby and Sheriff Cogan, but tangential individuals as well, where then under oath, in a room by themselves, the lawyers are able to probe and pick and inquire as to the decision making in this case, because the allegation is that this was a prosecution that was malicious in nature, that there wasn't any factual foundation for it. We have found through these trials that there's been insufficient evidence to convict, and I think actually it would have been egregious to go further against these individuals, and I think it was, quite frankly, egregious to go further beyond Nero, because you had judge's decision in Nero, and the charges were pretty much the same as the other defendants, and so I think finally they reached the point where they realized that this would be little more than a frustrating pursuit, and I think they realized that it would give fodder to the plaintiffs in the civil cases allegations that it was a malicious prosecution.
You've been listening to well-known defense attorney Warren Brown. We're going to head back to David Collins. He has more expert analysis for us in this developing story. David, are you there?
I am here, and I'm standing with David Jaros. He is a professor at University of Baltimore Law School, and I want to get your reaction to all this. What is your reaction?
Well, I think this was not a huge surprise. At the end of the day, the prior cases had suggested that this was a really hard case to prove. It was all along. And given what evidence the state had, at some point they have to ask themselves, do we have sufficient evidence to prove the case beyond a reasonable doubt? And if they don't have that, even if they believe a crime has occurred, even if they believe there are benefits to bringing a prosecution because of the deterrent effects it has on other officers' misbehavior, or because it reaffirms the value of every citizen's life, they have to believe they can prove their case beyond a reasonable doubt. And if they decide they cannot, then the right thing to do is to dismiss.
Now, most of us came prepared to hear a Castigar hearing. How rare is that in the state of Maryland and in general? And when it didn't happen, what was your reaction to that? So, or was that the straw that kind of broke the camel's back?
It may have been. The Castigar hearing is an extremely rare thing, and the reason they had to do that is that the state had compelled these officers who were defendants to testify in other cases, and I presume they were forced to do that essentially because they needed that evidence to come in those cases, but it put them in a very difficult position because they then had to show that no strategy they had in this case and no evidence they had was derived in any way from that compelled testimony, and that was a very difficult thing to do. My reaction was really one as a geeky law professor who was fascinated by the fact that we were going to have a Castigar hearing and very curious as to how they were going to satisfy that very difficult hurdle. But it doesn't mean that I think it wasn't the right decision. I think it probably was.
the right decision to not go forward with the charge?
To not go forward. When you look at the judge's reasoning in the other case, there was no question that he was open to the possibility that they would have more evidence. But absent more evidence, there didn't appear to be a way forward to a conviction. And if you can't get a conviction, at some point you have to fold.
Now, let me go back to the Castigar hearing, because we saw the prosecution put together what they call a clean team. They put together a filter team to make sure the clean team wasn't tainted, if you will. I mean, it seemed like they took the right steps. I mean, beyond that, how difficult would it have been to prove?
Well, so there were two aspects to what they would have had to show, and one would have been relatively simple. One thing they had to show is that all of the evidence they were going to offer was not derived in any way from the compelled testimony. And because they've already put on a great deal of the evidence, and they have a well-publicized investigation where they can point to exactly what their evidence was, they probably could have gotten over that hurdle relatively easily. The other thing they would have to show is that their strategy was not shaped in any way by communications with anyone else in their office. There's even the question that was posed to me, and it's a puzzler, of, could they read the decision of the judge in Officer Nero's case, which was, of course, shaped by the compelled testimony. And it just shows what a can of worms you open up when you compel a defendant to testify about the matter which they are also facing trial on. It is not a hurdle that I think they would have been unable to get over, and it's not clear to me that they made any mistakes in the steps that they were taking. There was a motion that was filed that alleged that there had been communications between the attorneys who witnessed the compelled testimony and the clean team, but those were only allegations, and there have been allegations throughout the trial, some of which have proven true and some of which have not.